An interesting decision out of the Supreme Court of Illinois. Specifically, they are applying the state freedom of information law to deny, that's right, to deny those individuals that have applied for concealed carry permits but were denied or rejected. They've denied the ability to get that information from the state under the FOIA laws. Crazy case involving the Illinois Supreme Court and Illinois law. Stay tuned. You're not going to want to miss this convoluted mess. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and guess what? I've been nominated for 2 Gundy Awards for the year of our Lord 2024 for the Male Influencer of the Year and the top voice of the Second Amendment. We'll see how it goes. Gundys are in Las Vegas in January 2024, but I'm honored to have been nominated in both categories. All right, folks, so crazy case out of Illinois. Usually when we're talking about Illinois lately, we've been talking about the quote-unquote assault weapon ban, which is a political propaganda term for banning semi-automatic rifles and magazines that hold more than 10 rounds. But today we're going to talk about a different case involving the Illinois Supreme Court, specifically that state's FOIA law, or Freedom of Information Act law. Under FOIA, there's certain information that you can get from the government. Now, before we get into the details of FOIA, I do want to mention, isn't it ironic how the government says they want to have a monopoly on force to defend us. They want to be able to protect us. They want to keep all this information, yet we know repeatedly government has failed to do their job. We know that it just was reported that the Israeli government, for example, were aware over a year ago that Hamas was planning an attack of what we saw in October 7th, 2023. Yet the Israeli government knew of this plot and obviously failed to stop it. We also know that many instances of quote-unquote mass shootings, such as the Parkland shooter Nicholas Cruz, he was known to police and law enforcement as somebody who would potentially be a school shooter, yet he wasn't stopped. So too we saw recently in the main mass shooter, the individual who had hallucinated and had talked about shooting up his military installation, yet he wasn't either civilly committed. Apparently he was, by the way. He was involuntarily civilly committed. That took a while to get out, but that's what happened, which means the government knew he wasn't allowed to have guns, and yet he still was able to get guns. Moreover, he was not arrested, because if you start talking about shooting up a military installation, it would seem to me that the Department of Justice ought to step in and do something about that. But I guess you're too busy with other things than actually protecting military installations from being shot up by a nut job in Maine. Nevertheless, let us carry on. When it comes to this situation in Illinois, it's a quirky case. So what the Illinois Supreme Court said in this case, which is entitled Hart versus the Illinois State Police, I'll put a link to it down below. The Supreme Court said if you look at the state FOIA laws, it provides that names and information of people who have applied for or received firearm owners' identification cards under the Firearm Owner Identification Card Act, or applied for or received a concealed carry license under the Firearm Concealed Carry Act, unless otherwise authorized by the Act, etc., those shall be excluded, and you cannot turn those over pursuant to a FOIA request. Now, the plaintiffs here said that doesn't make any sense because they are entitled to the information about themselves. They're not trying to get information about other people. They want information about themselves. They're seeking their own information. So logically speaking, according to the plaintiffs that brought this lawsuit, they already know their names and the information. They just want to have the documents associated with their application because apparently they wanted to go to court and challenge the court's decision that denied them, the cards and the access and the licenses that they were requesting. Nevertheless, the Illinois Supreme Court reversed the Illinois State Trial Court and the Illinois Appellate Court that both said that, yeah, of course, if you're asking for your own information about you are entitled to get that information. And this is particularly true. The lower courts relied on another provision of the State Freedom of Information Act that said specifically that although the provisions prohibit the disclosure of personal information contained within the public records, the disclosure of which would consist of a clearly unwarranted invasion of personal privacy, this is all, of course, unless, and this is the key language, unless, is what the statute says, unless the disclosure is consented to in writing by the individual subjects of the information. So here the plaintiffs consented to the disclosure of their own information about themselves and their own application to the state for these firearms-related licenses. And despite that language of that statute, the Illinois Supreme Court, guess what, reversed the lower court decisions that said that the plaintiffs won and they were entitled to this information. This Illinois Supreme Court said, no, under FOIA, the plaintiffs are not entitled to the information about themselves or anything along those lines. Now, of course, what's generally speaking, I understand at the one level, FOIA laws that say that you cannot disclose to the public information about people and their concealed carry permits or people and their gun licenses. I totally understand that at one level, which is you don't want people finding out who has the guns because you lose what's really a positive free rider effect, where if no one knows who has the guns, it means the people that don't have guns are essentially going to be protected in a sense by the people that do have guns, because if you're in a state where people are allowed to carry guns and have guns, which of course is the law of the land thanks to NYSERPA versus Bruin, that's the way it should be, bad people don't know who has the guns and who does not, which means that those people that don't have guns may be protected by virtue of the criminal deciding not to attack those unarmed individuals because the criminal doesn't know if that unarmed individual is armed or not. It's kind of like poker, secret information. You can bluff them, that kind of thing. So what's interesting, though, is although at the one level I understand why you have a law that says you can't get this information, but this is a different case. In this case of, again, Hart versus the state, Illinois State Police, this is different because they're trying to get information about their own applications so they can put together a case as to why the state police got it wrong. So it seems to me, whether it be under the FOIA law, especially with that written exception, they should be entitled to their information. Now, I will say on the in the fairness here, the court went on to say at the very end, it says, even though we disagree that they're not entitled to their own information under the FOIA laws, the court did say that we note that while the plaintiffs are not entitled to the disclosure of their requested information under FOIA, they may obtain their FOID, meaning the Firearms Owner Identification Card applications, and revocation letters through the Firearms Services Bureau, the division of the Illinois State Police that processes FOID cards and applications and determines the card eligibility. ISP, meaning the Illinois State Police, does not dispute this point, but simply maintains, as we have found here in this case, is what the Supreme Court of Illinois said, that FOIA is not the proper means for obtaining the requested information. Well, again, that may make some level of sense, but it does seem perplexing as to how they can interpret the FOIA rules to say that under FOIA, you're not entitled to your own information. On a related note, it also begs the question of why is government so secretive, especially when it involves this? It seems like every time American citizens are trying to get information about anything that speaks to public policy, the classic maneuver, whether it be by the state police in Illinois or elsewhere, or the federal Department of Justice, is to claim some sort of investigatory or investigative privileges to say, oh, we're looking into that. It involves some criminal investigation. But how many of us really believe that a lot of this is true anymore? That these investigations are real, and how many of these are really just an excuse not to turn over incriminating information that would make the government look bad? Inquiring minds want to know. Because certainly if you look at the behavior of this federal government by having open borders, where the most recent report this week is that there's almost 50 million, that's 50 million foreign-born individuals here in the United States, 50 million. It doesn't take a large percentage of that number to be in particular swing states or red states to flip them to the Democrats, right? And again, as we've talked about on this channel, how many of those immigrants, whether they be illegal or otherwise, are coming from cultures that have any kind of familiarity with the private right to keep and bear arms, or even a private right under a Bill of Rights of any sort, as opposed to individuals that are coming from cultures that are really, shall we say, not Western in nature, not freedom-oriented nature, not interested in fundamental rights and the like. How many of these people are coming from essentially criminal states? And I don't blame them, by the way, for trying to come here. I would do it myself. But once they get here, how many of them have been sort of inculcated or educated or have become learned in the Bill of Rights and the American constitutional system. I'm guessing not that many are, and it doesn't seem like in today's public education system they're going to be trained or educated by any of these public school teachers in America today of the proper American way of life. It seems to me that we're going in a different direction. So in that context, it really does make you wonder, why is it that all of these government laws are designed to protect government employees, government information, government sources, and whatnot, and keep this information from the public? So, all right, folks. Well, again, a lot of interesting public policy questions about Freedom of Information Act laws and transparency laws and the like. But again, it seems to me that there are serious policy arguments in favor of further disclosure and more disclosure rather than less disclosure in the modern era. Nevertheless, we can have that debate at another time, but it's interesting. I'll put a link to this Illinois Supreme Court decision. You can check it out for yourself and see if you agree with it. But in the meantime, I hope you learned something here at the Four Boxes Diner. If you haven't subscribed, please do so. Feel free to share this with your friends. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.